Hello, my name is Tim McCurdy and I am a guardianship lawyer practicing in St. Louis, Missouri. To pursue a guardianship, the first step is to prepare what is called the petition. This is the document that we file with the court telling the court that we believe someone is incapacitated and asking either for the petitioner or for someone else to be appointed as guardian. And the petition contains a lot of important information that you need to provide to the court, and it is also a good way to show the issues that can arise in a guardianship and the type of information that you need to help your attorney as you're preparing to petition for guardianship. So in our video today, we're going to be walking through the preparation of a guardianship petition so that you can learn both the process for a guardianship, the information that you would need to pursue guardianship, and also what to expect as you're going through the process.
For our example today, we're going to be using the form for petition for appointment of a guardian and conservator for an adult provided by the St. Louis County Probate Division. It's important when you're seeking appointment as a guardian or conservator to see if the county where you're filing has a form that is expected to be used when you're filing that petition. For example, in St. Louis County, they have a form petition that will also lay out for you all of the additional information that you need to provide and the documents that you need to gather that should be filed with the guardianship petition. And it's important to identify any forms that are available in your jurisdiction first, because the person who is reviewing this filing to initially screen it to see if everything is there that is needed to prepare the summons and give a hearing date is going to be familiar with the form. So the information that they're looking for, the things that they know that you need to have to be able to file your petition, are going to be in a spot where they're used to finding them, and it makes life easier for the individuals who are reviewing the petition. So anytime you can make things easier for them, then the faster your petition is going to go through the system. There's also a recognition that in creating these forms, the courts are identifying all the information that is necessary under the law in Missouri to meet the requirements of a petition for a guardianship. So it's a good way to make sure that you have everything that you need in your petition. It's also a good idea if you are in a county that does not have their own approved forms to use, as an example, one of the forms from, for example, St. Louis County or the city of St. Louis or Jackson County in Kansas City, where you can use these as an example or a template as you're preparing your petition. So in our example today, we will be giving the example of a daughter who is seeking guardianship of her mother. And in our example, the mom has dementia and Alzheimer's disease and is unable to live independently and needs her daughter to become the guardian. So at the beginning, in the matter of, we will put Molly, the mother, as the respondent. The respondent, there are two main parties. There's the petitioner, the person who files the petition. That's going to be Doris, the daughter. And there is the respondent. That is the person who is alleged to be incapacitated or disabled, and that, if approved, will have a guardian and or a conservator appointed for them. So we have comes now, and it'll be Doris, the daughter, and she is the petitioner. She's the one seeking the guardianship. So Doris, the daughter, who is the daughter of the above respondent. So here, it's easy when it's a family member, you just identify the relationship. But if it's someone who does not have a blood relation to the individual, you need to give some sort of description in terms of, okay, what's the relationship? Why is this person in the position of petitioning for the appointment of a guardian for the individual? So here, our respondent is a female person. Let's say she's 82. She's domiciled in St. Louis County, so that gives jurisdiction to the St. Louis County Probate Court to hear the guardianship proceeding. And say that the respondent lives in St. Louis. And then you have to provide addresses for the 3 years prior to filing, or if you don't know, then you need to say what you did to try to find out. The other useful part of using these forms is, as I mentioned, they walk you through the information that you need to include with the petition. And if the person petitioning for appointment is not a close relative, then they will need to also undergo a background screening. And if they're going to request appointment as a conservator, they will require a credit check. And these things have to be completed and provided to the court before the hearing. So it's something to be aware of, both timing-wise, to make sure that you get started on this process as soon as possible, because you don't want there to be any delays while you're waiting for the background checks or credit checks to be completed. But also something to consider when you're thinking about whether you should petition for appointment, or if there might be some issue for someone who is seeking appointment, either with a background check or a credit check, that if you have options in terms of who might be the right person to petition, be aware that you may have to undergo those screenings. They also ask about if the respondent has a driver's license. Here we'll say no. Or if the respondent is registered to vote, we'll say yes. And the court is asking that specifically because that can be addressed directly in the guardianship order. That if there's an appointment, and they're going to say the scope of the guardianship appointment, and some of the things they can address is whether or not the individual can still drive, whether or not they're going to lose their right to vote. And again, this form is walking you through additional items that you're going to need. There's the financial statement for the respondent, and there is a list of interested parties. So when the petition is filed, the next step is the court will give a hearing date, but then notice has to be given of that hearing date. The respondent, Molly the mother, who will have a guardian appointed if approved, she gets served with a copy of the petition along with all of these documents, and she's told when the hearing will be. She's told about what it means to have guardianship appointed, what her rights as the respondent are, and that who the guardian ad litem who's being appointed is, and they're entitled to that information. But there's also a requirement that we provide a list of interested parties. So this would be parents, spouse, living children, closest known relatives, anyone who's living with the respondent, and it goes through a list of individuals, and they are required to receive notice of the hearing and identification of who the guardian ad litem is, and the idea being that they don't necessarily get, they don't get served with the petition, they don't get all the information, but they're made aware of the fact that this is happening and when the hearing is going to be. So if they have any interest in the proceeding, if they are going to contest the petition, or if they believe they should be the ones who are appointed, they have notice, they have an opportunity to come to court and be heard and to make their claims. So this is something that you're going to have to provide to the court to satisfy the notice requirements of the statute. Then we get into kind of the heart of the petition, the key part, which is where we are giving the factual basis for seeking the guardianship. And there are a few things that you need to complete here. One is whether or not you are seeking a full guardianship or a partial or a limited guardianship. So are you saying that this person is completely unable to make decisions, or are they only partially unable? So here we're going to say that Molly the mother is unable by reason of, and then this is normally going to be the diagnosis of the individual. A key part of any guardianship petition for an adult is going to be what we call physician's interrogatories. This is a statement from a physician indicating the diagnosis of the individual and why they are unable to make decisions for themselves, why they need a guardian appointed. So when you're filling out this information, ideally you will already have the physician's interrogatories, and you'll be taking the information directly from those. So here, by reason of dementia and Alzheimer's disease, Molly the mother is unable to receive and evaluate information or to communicate decisions to such an extent that she, and again, you're deciding, is it fully lacks capacity or is it only partially lacks capacity to meet essential requirements for food, clothing, shelter, safety, or other care such that serious physical injury, illness, or disease is likely to occur, and or to receive and evaluate information or communicate decisions to such an extent that the respondent, again, either fully or partially lacks the ability to manage his or her financial resources or meet their daily needs of living. So these definitions, this language comes directly from the guardianship and conservator statutes. So by using this form, you are using the precise language that would come from Missouri law. And you're saying that this individual either completely is unable to make these decisions, receive information, manage their finances, or it could be partially, that they're able to do some things, but they're not able to do others, such that, and then you indicate that you're either seeking a full guardianship or a limited guardianship and conservatorship. And that's exactly what it sounds like. Either I am asking to be able to do absolutely everything for this individual, or it's only necessary to have it be a partial guardianship and conservatorship. So remember, this long sentence or paragraph starts with the factual basis, the reasons that we're saying that Molly the mother is unable to make decisions, and we identified the diagnosis. But now we're going to go to specific description of why this person is incapacitated. And this will come directly from the physician's interrogatories. For example, if the physician's interrogatories say that the individual has a cognitive impairment, prohibits independent decision making, inability to understand her surroundings, and this is just language that is not specific to her. It's just something I'm making up in order to show and give you an idea of what information you would provide here. Again, this would come directly from your physician interrogatories, where the physician is saying this is what the person cannot do. Now, if you had indicated a partial impairment to where only a partial guardianship is sought, then you're asked to provide additional information about that, so that you're explaining why it is that you are only being appointed to manage certain parts or aspects of the person's life, and that they will be able to do some things. So you need to go into more detail about exactly what the person's disability is, if it's only a partial incapacity or disability. So then you've said this is why the person needs a guardian, and now you're saying that you want Doris, the daughter, to be the one who is appointed the guardian. And they have space for two individuals here, keeping in mind that there's no requirement that if you have both a guardian and a conservator, it doesn't have to be the same person. And also, in unique circumstances, you can request appointment of co-guardians if you have two individuals who want to be appointed, but you have to explain why that's necessary. That's not going to be the norm. just understanding that there can be difficulties that arise when you have two people making decisions for one other person. And, whether it's just a matter of, do you need both individuals to sign off on everything? What if one person isn't available? Who's going to have the authority to make decisions? And then also the potential for disagreements between two people fulfilling that role. So if you're going to do that, you're going to need to explain why it is that that's necessary. And then we walk through the additional items that are needed to be filed with the petition. There's the consent to appointment, which is the person who is identified as the guardian, that they consent to that appointment, and designation of resident agent. That would be if the person who is going to be appointed guardian is located outside of the state of Missouri, then they're required to have a registered agent, the same as if it was a company that's located outside of Missouri, but they do business in Missouri, and they need someone who could be there to receive notifications from the court. So they have to have someone designated in Missouri. Also a list of witnesses that when you have a hearing, that the individuals identified as witnesses are the ones that you're going to call to testify. Now, when you have your list of witnesses, it doesn't mean that you have to call every single individual to testify, but understand that if you don't have someone listed as a witness, then you may be prohibited from calling that person to testify at the hearing. And finally, we have what we call a wherefore petition, which is the ending of a petition where you're telling the court, this is what we're asking to be done. And we're asking that the court hold a hearing, and that after that they appoint Doris, the daughter, as the full guardian of the person and full conservator of the estate of respondent. And then you're going to date that, and it's under oath and affirmation, and then it has to be signed by the petitioner along with their address, the telephone number, and then the attorney's signature. And the last part of the petition is to give an address where the respondent can be served. Once the petition is filed and it's been approved by the clerks in the probate division, they will prepare a summons, and then the petition has to be served on the respondent, the person that you're going to court to say they need to have a guardian appointed. They have the right to receive a copy of that, to get notice of when the hearing's going to be, who the appointed attorney is going to be. And so this is you giving an address for that individual. And then there are numerous exhibits that have to be completed, and in a separate video we'll talk about completing the additional exhibits that have to be filed, the information that you have to include with your petition. Hope you found this information to be useful. Keep in mind that this is general information and it should not be used to make legal decisions about your own unique needs. And if you have questions about guardianship and pursuing a guardianship petition in Missouri, feel free to give me a call, and I'd be happy to answer any questions that I can. Thank you.